When hundreds of thousands of tons of steel violently collide at sea, the resulting physical destruction is immediate. On land, the rule for accidents is pretty straightforward. If you break something, you buy it. A multi-million-dollar crash should mean an immediate, company-ending bill for the person responsible. But maritime law operates on a different logic. The simple fact that a ship crashed into another vessel or destroyed property does not automatically make the shipowner legally responsible to pay for it. Instead, courts process the aftermath through a strict sequence known as the chain of liability. First, they establish fault, then prove causation, then assess the specific damages, and finally apply legal limitations. Courts apply this specific progression to every major incident. It acts as a regulatory buffer, ensuring the financial aftermath of a crash follows a predictable path rather than an unchecked spiral of litigation and corporate bankruptcy. Let's say Ship A and Ship B collide. The very first hurdle is figuring out exactly who is to blame. The simplest outcomes work like this. If the crash is a pure, unavoidable accident, each party bears their own losses. If only one ship is negligent, that owner takes the full liability. Under India's Merchant Shipping Act of 2025, courts use apportioned fault, mathematically dividing liability. Then we move to causation. Liability only attaches to damages directly connected to that fault, like lost cargo, destroyed infrastructure, and personal injuries. Proving a captain made an error is only half the battle. The court has to draw a legally binding line from that specific mistake to the physical destruction it caused before anyone pays out. This brings us to the final part of the chain, limitations. Much of the world relies on the LLMC convention to set these rules, though notably the United States opts out. Under the LLMC, a ship owner's financial liability is capped in a highly specific way. It is calculated entirely from the physical tonnage, the size and volume of the ship, completely ignoring the total cost of the victim's claims. Because shipping is inherently international, courts can't peg this financial cap to a single local currency that fluctuates wildly. Instead, the global maritime system relies on special drawing rights, or SDR. This is an international reserve asset maintained by the International Monetary Fund. The SDR operates as a basket of 5 major currencies: the US dollar, the euro, the Chinese yuan, the Japanese yen, and the British pound. To maintain economic stability, this basket is valued daily against the US dollar and meticulously reweighted every 5 years. The legal system intentionally restricts a victim's payout using a synthetic global currency and ties that restriction directly to the physical size of the ship that caused the damage, rather than the severity of the damage itself. So why cap liability at all? Why build an entire international framework specifically to let a negligent ship owner? Without a clear, tonnage-based ceiling, insurers would be trying to price the infinite risk of an unconstrained collision, making coverage impossible to underwrite. That creates a domino effect. If insurers can't guarantee a policy, banks will categorically refuse to finance the construction or daily operation of the ships. Because the cap exists and the math works, these insurance policies are now legally mandated to cover at least the amount of that statutory liability limit. Without this financial ceiling, a single severe collision could bankrupt major shipping firms, stranding fleets that supply the world with food, fuel, and goods. This chain of collision liability functions as a calibrated global algorithm. By balancing victim compensation with tonnage-based limits, it allows the maritime industry to settle its debts while keeping the vital infrastructure of international trade in motion.